May as well get started. Let's get going. Welcome to today's webinar rather, Procurement Law Update 2025, presented as part of the EM Lawshare training program. Just so that I don't forget, because I have a tendency to do that, there are some feedback forms, so please complete those at the end of the session and send those in, or provide whatever response you can. I think it's by form or some form anyway. It's really useful to us if you can do that because it's helpful to understand what sort of things people are interested in, and it also just good to get feedback on what we deliver. So if you could do that, it'd be much appreciated. I'll remind you again at the end, just so that you don't forget and I don't forget. But anyway, my name's Nathan Holden. I'm a partner at Freeth, and I'm responsible at Freeth for leading the local government sector. I predominantly provide commercial advice in all sorts of forms to primarily local authority clients. So when I use the word commercial, I use it rather loosely, and that would cover advising around procurement issues and also in the context of real estate transactions as well. So I have a mixed bag of work. When I came to present this seminar or think about presenting this seminar, it struck me that an awful lot had been written and said about the introduction of the Procurement Act 2023 and drawing comparisons with the 2015 public contract regulations and the concession regulations, and also, where applicable, the utilities contract regulations. And it seemed that an awful lot had been said about that particular topic, such that it was felt as if it had been done to death. And so what I thought I'd try and do with this session was try to pick out where I thought there were, I don't know, new case law of relevance, and also potentially areas where there remains some ambiguity still in relation to the new Procurement Act. We are, as I say, in a bit of a hiatus stage here because much of the case law that you do see at the moment still reflects the public contract regulations. I'm not aware yet of any cases that have been brought specifically under the Procurement Act, although of course it is early days. And also, yeah, I'm not aware of that fact. And also, I suppose it takes time for new rules and regulations and the Act to bed down. There is an awful lot of it, much more so than under the public contract regulations. So I guess, suppose, having been implemented in February, we're only now in November. And so I suppose there's still time, or there still takes time for those sorts of issues to bubble up. So anyway, what am I proposing to cover in today's session? Try and get the slides to move. Yeah, that's the different panel members. So I'm going to look briefly at the transitional provisions, how they work, what they do, and what they apply to, and where I perceive to be, or I understand there is some ambiguity, which I think is worth exploring. Look at some of the relevant cases, in particular, look at how particular approaches are taken currently under the existing public contract regulations and how they reflect the law as it stands. And indeed, I suppose there's still an argument for suggesting that some of those cases that relate to the public contract regulations are still going to apply because of the way in which the transitional provisions operate, in that they effectively retain a body of decisions until they reach their conclusion, those contracts reach their conclusion, because that's primarily what the transitional provisions do. And then look at some areas of ambiguity, and also look at quite a recent claim, which I think is quite interesting because of the approach it takes. It's only in early stages, that claim. It's only been issued in October, so it is very early doors, but fundamentally it may have some implications for the approach that's taken in the future. So looking firstly at the transitional provisions, for those that are not familiar, obviously the role of the transitional provisions is to manage the changeover between the public contract regulations 2015. I won't bother talking about the other regulations, but treat it as read, that I'm referring to those regulations as a symbol for all three sets. And the new Procurement Act 2023, I think I probably have to stop calling it the new Act, given that it's now been enforced for some time. But anyway, I'll call it that for the purpose of this seminar, the 2023 Act. And what they do is to ensure that procurements that are already underway when the new Act came into force can continue, and contracts awarded under those rules will remain governed by them until they effectively end. And the expressed intention is to avoid restarting or invalidating any ongoing processes. Now, these provisions that allow for the transitional provisions are contained within the Procurement Act at sections 122 and 127. And of course, they were brought into effect because those provisions only allow for the creation of some kind of order or regulation by the Procurement Act 2023 Commencement Number 3, Transitional and Savings Provisions, Regulations 2024, and in particular, Regulation 85, which provides for transitional provisions, which on the face of it would appear to be quite clear, because they state, having been amended because the date for when the implementation of the new Act switched from October to February, provide that if before the 24th of February 2025, the contracting authority has submitted a contract notice or contest notice for publication under the PCR, awarded a contract, concluded a framework agreement, and frameworks is where I'll come back to, or established a dynamic purchasing system under the public contract regulations, published a voluntary transparency notice under the public contract regulations, published information on contracts finder under the public contract regulations, contacted an economic operator to start a negotiated procedure without prior publication under the Regulation 32 provisions of the public contract regulations, the ability to directly award under certain circumstances. Now, of course, if you've done as a public body or a contracting authority any of those things, then effectively those provisions will continue, or that process will continue to run until its eventual end. And that's how the transitional provisions intend to run. So anything you've commenced, in effect, as a public body prior to that date, pretty much is caught by those transitional provisions and will be subject to the public contract regulations 2015 until the bitter end, until those contracts have been awarded and any subsequent variations have been made or anything else, and they brought to a close. The interesting part, however, of course, I think is in the context of framework agreements. And I think this is where I would suggest that there is some potential uncertainty, and an issue that's been raised specifically in me at one stage or another. And that is this fundamental difference in approach under the public contract regulations to framework arrangements, and how that contrasts with the Procurement Act 2023. Now, under the old public contract regulations, the concept of frameworks was largely, so there's some chat. Oh, no sound on the presentation. Oh, okay. Sorry, is the sound working now?
It's been sorted now.
Oh, okay. Sorry. Yeah, I saw that quite late. Sorry about that. Okay. Yeah, sorry, I'll carry on. Under the old public contract regulations, once a framework was lawfully established, effectively you could call off under that framework, and in the framework was primarily, or the call-offs under that framework was primarily a carve-out from the regulations. So long as you complied with the framework terms on awarding contracts, then any contract awarded under it was a carve-out. And some people often felt that that was, to an extent, a bit of a get-out-of-jail card, because fundamentally, if you could establish a framework, you could then effectively depart from the provisions contained in the public contract regulations and effectively escape from those provisions in relation to those call-offs, so long as you met the requirements that you didn't exceed the threshold that was provided for in the framework, that you stuck to the terms of the framework. And of course, I think there were some more strict provisions as they related to direct awards. So I think you had to follow a more strict process. But by and large, they were an opportunity to escape from the regulation that the procurement public contract regulations imposed. However, under the Procurement Act 2023, there's a change of perspective. Because in effect, what the Act does is it categorizes call-offs as a type of separate public contract. And what the Act potentially does is that it subjects them primarily to the full gamut of obligations that apply to any form of new procurement. So the question that then this raises is, if a framework has been established under the old Act, and then you come to call off under the new Act, and under the new Act, that call off potentially was caught by the procurement as a new procurement event under the new Act, under 2023 Act, then does this in effect trigger the obligations to comply with the Act? So what would this necessarily require? Well, it may require that you would have to meet the transparency obligations, you'd have to apply exclusion grounds, and also you'd have to comply with new rules on contracts, awards, and reporting. So you might say, well, that seems quite harsh, but anyway, what is the logic that sits behind that? I mean, that is what the legislation provides. Well, the rationale behind that approach is it's rooted in the Act's emphasis on openness and accountability, and it's attempting to treat all call-offs as independent contracts. So that ensures that each award is subject to scrutiny and aligns with modern procurement principles rather than effectively using the framework as a shield. So what it's effectively doing is it's seeking to accept that a framework is a slightly different type of animal, slightly different type of approach. It does give some flexibility within its approach, but to ensure you comply with transparency and all of those other provisions, it ensures that when you come to call off contracts, there's a degree of transparency. So you don't have this, as I say, carve out anymore. And I think that's quite a fundamental point. So then, of course, this is problematic, as I say, in the consequence, in the concept, or it's problematic in the application of the transitional provisions, because the question then arises is, well, if you entered a framework, are you then called as you call off, or are you able to say that those call offs are subject to the old PCR and not subject to the new rules? And this, of course, is a significant area of doubt. Now, personally, I would have thought a logical approach would be to suggest that contracts that are awarded, frameworks that were created under the old PCR, where contracts are awarded under the PCR, then of course they should be subject and continue to be subject to the old PCR because they are a product of that arrangement. And in fact, indeed, may have been established long before the new Act came into force, because it could be that you could be near the end of, or it could be that the framework is more than, say, 4 years old. That's entirely possible. So I think that seems to me to be the logical explanation, but I can well understand why there is that degree of ambiguity, because of course it's clear from those that sought to draft the transitional provisions that the intent was clear: try and keep that which has already happened and in progress alone, and anything new would be dealt with under the new Act. But of course, that's not quite how the Act works, because you've got two colliding or different types of approach as they relate to frameworks, hence the ambiguity. So I think that's one area that needs to be treated with some caution. But as I say, in my world, in my view, I think the answer probably is that call-offs that are awarded under PCR created framework arrangements should remain enforceable by those arrangements. But it'd be interesting to see as and when we get some kind of judicial opinion on that. And I suspect the reason it was missed off is it's a bit of an oversight. No one fully understood or appreciated that distinction, or maybe they did and thought we'll just wait for the courts to determine it. So that's the first point I would like to make. And now I'd like to just talk a little bit about some of the different cases that we've had. First, to talk about Millbrook Healthcare Limited, which is a 2025 case. I've tried to keep them to 2025, unless there's a particular reason to do so. But this is just mainly to keep you up to date with some of the cases. Some of it is relevant still to PCR cases, I say. Some of it has certain resonances to the new Act. But of course, while we're still dealing with PCR decisions or procurements that progressed under that, it's still relevant to look at it. Now, in Millbrook and Healthcare Limited versus Devon County Council, as most of you will know, where a procurement challenge is made, the immediate effect of bringing a challenge is that it imposes an injunction on the public body such that it cannot, assuming it is yet to award a contract, continue to do so unless the court permits. So there's what's known as the automatic stay applies. Now, of course, this is quite an unusual concept in English law because typically an injunction is something that a party would normally have to apply for. So it is slightly odd and a bit of a European style concept that simply by issuing a claim, you get this automatic injunction. And I think it would be fair to say the courts have never necessarily been particularly fond of the automatic stay process. And indeed, in most instances, lift the stay, primarily because I think the argument is that in the majority of cases, to stop a party from entering into a contract when damages are a suitable remedy is in effect too powerful a remedy. So I think that's where the logic sits, or that there has to be very powerful reasons as to why you should prohibit a step being taken when damages are always there sitting in the background as an alternative. So I think that the courts, as I say, have never been particularly fond of that provision. Now, in the case of Devon County Council, what that was all about was a procurement of £46 million worth of community equipment services from a company called CES and technology-enabled care services. Millbrook Healthcare Limited, the incumbent supplier for 7 years, lost out the tender to a company called Nottingham Rehab Limited. And Millbrook challenged the award under the public contract regulations. They issued proceedings in January 2025. So, of course, this was just before the new Act came into force, but that wouldn't have mattered because this had been procured under the old rules. And of course, that automatically triggered the automatic suspension and prevented the council from entering into the contract. Devon County Council applied to lift the suspension while Millbrook sought an expedited trial. They wanted to get the thing resolved as soon as possible, arguing that damages would be inadequate due to reputational harm, staff losses, and diminished competitiveness. Now, not surprisingly, the Technology and Construction Court lifted the suspension, which I said is quite common in these cases, and it made the following points. The court reaffirmed that the Frankovich sufficiently serious test for damages is irrelevant at the interlocutory stage when deciding whether to lift an automatic suspension. Well, the Frankovich test or the Frankovich principle is very much again a principle of European law, which is the idea that not only are you entitled to compensation for breach of contract, but where there's been a breach of the procurement rules, there should also be a separate species of compensation available to a party. Now, the courts have always been a bit reluctant, even the European courts have been a bit reluctant to open up the door to compensation on that basis and have tended to resist its application or reserving it for sufficiently serious cases. And there is a body of case law which focuses on circumstances when such compensation might be available. And normally that would require that there's a serious breach and there's a causal connection between the failure of the regulation, the application of the regulations, and any kind of loss suffered. So it is quite a narrow area. Now, so that was one aspect. Court affirmed that sufficiently serious test for damages is relevant to the interlocutory stage. So what they were trying to argue is that that was relevant to whether they were able to have the whether or not they could have the injunction lifted. Yeah, that's right. Devon County Council applied to lift the suspension while we sought an expedited trial. So they wanted to, they argued, of course, that they wanted the suspension to stay in place so they could resolve that issue by virtue of the expedited trial. Now, the court applied, as it normally does in these circumstances, the balance of convenience test. Um, Now, this test, of course, attempts to weigh the balance of the harm of lifting the injunction versus not lifting it, and tries to reach a decision on that basis. So effectively, what it's trying to do is it's trying to determine whether or not um, the harm caused by lifting the injunction and therefore letting the contract be awarded is in the public interest versus i.e. the public interest being to award contracts versus the harm to the individual party. Because, of course, once the injunction's lifted, the contract's entered into, then the claimant can only get damages. Clearly, the claimant wants the injunction to remain in place because that may ultimately give it more leverage in terms of trying to resolve or trying to get some kind of resolution. And the court made it very clear that claimants must provide detailed, verifiable evidence to resist lifting the suspension. So effectively, it's up to the claimant to demonstrate. In this case, it was established up to the claimant to demonstrate quite clearly what they've suffered, why they've suffered it, what will suffer if the injunction is lifted. And the court, as it suggests, is not going to be too keen on allowing an injunction to remain in place unless you can demonstrate as a claimant the basis upon which you can show what loss you'll actually suffer. Now, why is this important? Well, the judgment is significant for public procurement litigation because, one, it clarifies that damages are usually considered adequate unless strong evidence proves otherwise. So basically what it's doing is it's making it much, much harder for incumbents who want to challenge to maintain suspensions. It underscores the public interest factor, prioritizing timely delivery of essential services over commercial disputes. It signals that courts will scrutinize claims of reputational harm and competitive disadvantage, requiring objective proof, not assertion. It also provides guidance for contracting authorities and bidders under the PCR 2015 and the relevant transition provisions on how the courts will approach interim relief. So I suppose, in summary, what it does is it's an example of where the courts have taken quite a firm line in suggesting that they weren't willing to allow the automatic stay to be in place. And if you want the stay to be in place, you really need to manage to demonstrate some significant harm that you'll suffer. And I suppose that it was also trying to suggest that the fact that they were trying to allege there'd been a breach of the rules. I think in that instance, Millbrook were trying to argue that the mere breach of the regulations would justify a basis for maintaining the suspension because that of itself was sufficient harm to their interests, which would then justify that suspension staying in place. And the court said, no, the Frankovich test is not one that you apply at that stage, and it's something that you would consider potentially at a later stage. So you can't use that as a tool of your armory for suggesting that that a stay should remain in place. Now, moving to the next case, Robert Heath Heating Limited and Orbit Group. This again is a 2025 case. Here, the claimants were Robert Heath Heating Limited, which is a large heating and water systems installation and maintenance company. And the defendant in this case was the Orbit Group, who I think are quite well known, large registered housing provider, managing over 47,000 properties in the UK. Now, the procurement was by Orbit Group, which ran a tender for domestic and commercial heating services as long ago as 2023. And the contracts were awarded based on the most economically advantageous tender with 40% price and 60% quality components. Robert Heath Heating submitted to bid but lost out on lots 1.1 and 1.2, which was domestic heating services, to a company called Air and Services Limited, which is part of the much bigger SureSave group. Now, RHH, as I'll refer to them to save me having to say Robert Heath Heating, RHH claimed that, first of all, that a former employee of the Orbit Group had been involved in the procurement as a member of staff at Orbit, and then had later joined Aaron's parent company. So clearly, there's straight away potential for some kind of conflict of interest, raising obviously concerns about fairness and impartiality. And then on the scoring, they alleged manifest error in tender evaluation and argued that Aaron received unjustifiably high scores, reaching principles of equal treatment and transparency. Of course, the claim was made, which gave rise to the initial automatic suspension applying. The court, in assessing whether or not to allow the automatic suspension to stay in place, applied the balance test, which is, of course, the American cyanamide test, to decide whether to lift it or not, and went through the normal steps, whether there was a serious issue to be tried. Court agreed there was, whether the damages would be an adequate remedy. Court held there would be. And then it applied the balance of convenience versus public interest test. And the court also ordered limited early disclosure of documents related to scoring alleged conflict, reinforcing transparency in litigation. So that's another part of this, which is clearly you have to come to the litigation with clean hands, as it were. Now, why is this case particularly important? Well, it reaffirms that even where serious procurement issues exist, the courts will generally lift automatic suspensions if damages are adequate. So it goes back to the same principle, and it aligns with the Millbrook case, which is that clearly the courts are not very keen to maintain automatic suspensions. And in circumstances, in a vast bulk of cases, they will lift those suspensions because in most cases, damages probably are an adequate remedy. In the context of the whole issue on conflicts of interest and the employee who'd worked for Orbit and then gone to work for Aaron, the case underscores the need for contracting authorities to be really careful about how they manage staff movements and monitor conflicts rigorously. And obviously, under the new Act, conflicts are far more important and significant issue. And it's very clear that any failure to do so can potentially lead to litigation. So clearly, if you are in a situation where there is an individual like this has worked for, say, one party and then switches to the other, then you really do have to be very careful about those potential conflicts or the appearance of conflicts of interests. Transparency in the evaluation of tenders. The case also highlighted the importance of clear, defensible scoring methodologies and compliance with the public contract regulations obligations. I think there was an issue in the case around the adequacy of some of the decision notices. So that was just a minor point about that. Now, what kind of practical lessons, I suppose? Yes, again, if you want to maintain a suspension, you're really going to have to come up with some pretty compelling evidence to genuinely show why the balance of convenience should be weighted in your favour to maintain that particular suspension. So again, another case focusing on that. And I'll come back to these cases near the end because there's a point I'd like to raise about the new Act, which I think is important to talk about. Moving to the next case, Brace Yourself, which is a great name for a company, given the nature of what they did. But anyway, this case arose from NHS England's procurement of orthodontic services under the public contract regulations. Brace Yourself, the incumbent provider, lost the tender by a narrow margin, 80.25 to 82.5. So tiny differences, which always is the case. It's always very, very narrow margins, which give rise to people feeling that there's something worth fighting. And the High Court found that NHS England had made a manifest error in scoring accessibility, misunderstanding Brace Yourself's proposal for a stair climber as opposed to a stair lift. Now, I didn't know the difference between a stair climber and a stair lift, so I had to look it up. And a stair climber is some kind of portable mechanical stair climbing device, often for wheelchairs. And the stair lift, of course, is a fixed rail system with a motorized chair for independent travel. So quite why that was significant in this case, I don't know. But anyway, there's a distinction between those two things, and there was misunderstanding in relation to those things. And it said that by correcting this error, that would have made Brace Yourself the winning bidder. However, the court refused damages, ruling that the breach was not sufficiently serious under the Frankovich principle. Brace Yourself appealed, arguing that awarding the contract to the wrong bidder should automatically meet the seriousness test. So what they were attempting to say was, well, hang on a minute, if you failed, if complete failure to award the bidder to right because you've made some manifest error in terms of the way you've assessed what someone's offering, surely that's enough to trigger an argument that the sufficiently seriousness test has been met, so the Frankovich principle applies, so therefore there'd be an entitlement for compensation on that basis alone. Now, the court upheld the highest court decision, suggesting a breach that changes the outcome does not automatically qualify as sufficiently serious, which I find quite extraordinary. But anyway, that's what they said. And then it goes, they then talked about these principles called the factor-tame factors, including the nature of the breach, its excusability, and whether it was in good faith. So they were suggesting that just because something does not, just because a breach that changes the outcome does not automatically qualify as sufficiently serious, because they were effectively saying that, of course, it all depends on why the breach occurred, and if it was in good faith, then you wouldn't be able to rely upon the Frankovich principle and get compensation purely on the basis of a breach. It said the NHS error was inadvertent, isolated, and occurred in an otherwise well-run procurement, so damages were denied. So the court confirmed that Frankovich criteria apply to procurement claims because the PCR 2015 derives from EU law. This means that claimants must prove not only causation and loss, but also that the breach meets a high seriousness threshold. So again, I think this is another nail in the coffin for trying to bring claims on a sort of Frankovich basis. This sufficiently serious basis, and it's pretty much shutting the door on it in other than incredibly flagrant conscious decisions to breach the regulations, which are sufficiently serious as to merit the award of compensation. So it feels as if that whole branch of potential claim is gradually being pushed out of the way. So what's the importance of this case? Well, I suppose it's a landmark ruling on the application of damages in these circumstances, the Frankovich principle. And as it says, even if it confirms that even if a breach changes the outcome, damage is not automatic. The bar is very high. Factor tame, factor reinforce. The judgment emphasizes that courts will weigh factors like excusability, good faith, and systemic compliance. This is minor. Good faith errors in otherwise robust processes are likely to attract damages. So as I say, it really has to be very, very serious. Practical impact on litigation strategy. Well, I suppose what it means is that you're not going to be guaranteed compensation. And it does provide some reassurance to authorities that if you make the odd isolated mistake, then that isn't necessarily going to lead to damages on this basis. So I suppose that's some comfort. Now, the next case is CGI IT UK Limited, the Department of Finance. Now, this is a Northern Ireland case, so I always feel you have to treat those with a light bit of caution because you're dealing with a separate jurisdiction, although the rules are pretty much similar. The case arose from a challenge by CGI IT UK Limited against the Department of Finance, which is Northern Ireland Treasury in effect. It concerned a major public procurement process for a new land registration delivery partner project. The project aimed to modernise land and property services through a digitally enabled ICT solution. The procurement was governed by the Public Contract Regulation 2015 and conducted via a competitive dialogue procedure under Regulation 30. The dispute followed Department of Finance's decision to award the contract to Fujitsu Services Limited, which CGI contested. Now, what were the key issues in the case? First of all, compliance with the Public Contract Regulations 2015. The case considered whether the department adhered to the principles of transparency, equal treatment, and non-discrimination during the competitive dialogue process. Other aspects it considered: judicial review in procurement. Judgment clarified the scope of judicial intervention in procurement disputes, particularly under the remedies regime. and also looked at the adequacy of damages. It looked at the significant aspects as to whether damages would be an adequate remedy for CGI, or whether the court should maintain the automatic suspension test. Again, back to the same principle: is it legitimate to maintain that? And the judge in the case, Humphreys J, referenced the brace yourself limited case, which I've just mentioned, reinforcing that suspension depends on balancing public interest, prejudice to parties, and adequacy of damages. Well, why is this case important? Well, I suppose the decision provides guidance on applying competitive dialogue rules, which you might argue is a bit of a passing issue, given under the new regime you don't have that as a process, although albeit a process can be constructed under the new act, which mirrors that under the competitive flexible banner. Evaluating fairness in complex ICT cases, it emphasizes rigorous compliance with procedural obligations to avoid challenges. The case is also pivotal for understanding when courts will lift automatic suspensions under Regulation 95, confirmed that suspension is not guaranteed and depends on whether damages suffice, shaping litigation strategy. So basically what it's doing is it's going back and confirming the balance test, the American cyanamide case, indicating that it's going to be a rare event, that you're going to have circumstances where the automatic suspension won't be lifted. So it doesn't really move the law on a lot, but it just supports what has already been said. And in terms of its value generally, well, it was cited in the Millbrook case, so I suppose it does have some significance there. Moving to the next one, Working on Wellbeing Limited, Optima Health versus the Department for Work and Pensions, a 2025 case. Now, this case arose from a procurement dispute under the Procurement Act. The Department of Work and Pensions tendered for occupational health services under RM 6182, the Crown Commercial Services Framework. Optima Health submitted a bid that contained minor pricing errors. Another circumstance where this time the mistake wasn't made by the contracting authority, it wasn't made by 3 out of 133 service lines exceeded the framework maximum price. The bidder made a slight mistake with an overall impact of only 0.02%. So they made a tiny error in their pricing submission. Despite Optima's bid being the highest scoring on quality and likely to win, the Department of Work and Pensions excluded it without seeking clarification, citing non-compliance. So effectively, they just took the approach of, there were a few errors, there was no clarification exercise, so we will just reject that bid. The High Court upheld the Department of Work and Pensions decision, so effectively said, well, tough luck if you don't comply with the rules as strictly as they're applied, as strictly as you're told, i.e. you don't specifically comply with the rules very, very closely, then it's perfectly legitimate to be excluded from a process. But Optima appealed. Now, the Court of Appeal overturned the High Court's decision and argued that the Department of Work and Pensions had acted irrationally and disproportionately by excluding Optima, without seeking to try and clarify what were quite obviously very minor errors. So clearly that suggests that it puts the onus on contracting authorities to at least assess whether or not it thinks that an error is worth clarifying, or whether they should. I don't think you could just simply say, oh, they've made a mistake, we'll accept that. If it's relatively minor, then it's something that you're going to have an obligation to clarify. Now, this is going to be the case whether or not you're dealing under the old rule, under the old PCR or the new Act. Another interesting part in the case was the court determined that the invitation to tender lacked clear, unequivocal language mandating exclusions for such errors. So that's quite interesting. So there was nothing. No, I haven't actually looked at the tender, so I don't know what it actually says. And most tenders do usually say, do have clear and unequivocal language. So I'd be interested to know how this was not felt to be clear and unequivocal. And I'd be amazed in a project of this type that they wouldn't have had clear and unequivocal language. But anyway, that's what it said. Invitation to tender lacked clear, unequivocal language mandating exclusions for such errors. So does that mean in all circumstances you need to be very specific about an error on the basis on which you're going to exclude, or can you be more generic? interesting question. And also it made the point that contracting authorities have the discretion to seek clarification, and in cases of obvious and immaterial mistakes, this discretion almost becomes a duty, which is quite onerous, really. So I think that case is a bit of uncomfortable reading in many ways, because I think what it's really saying is you can't just assume that just because a bid comes in and someone's made a mistake as a bidder, that automatically you can just reject it and say, well, these were the rules, you didn't comply with them, end of. It places that onus and obligation on the contracting authority to make judgments about is an error worth clarifying or should be clarified, and is it minor? So I think it's actually quite an important case from those on that basis. Because we did historically have a slew of cases where it was quite clear the courts had taken the line that if you didn't comply with the rules, for example, if you slightly missed the deadline or just got your bid in slightly late, you would be the acquiring of the contracting authority could effectively exclude you, and we'd seem to have a series of cases where there was a very strict approach taken to compliance with requirements that the ITT set out, and here we seem to be shifting away from that slightly. And as it says in one of the commentaries, the court emphasised that procurement rules must be clear, precise, and unequivocal, and authorities must act consistently with the principles of transparency, equal treatment, and proportionality. Which, I mean, interesting thing to say, but you might argue that if you have a set of rules and everyone else has complied with them, or other bidders have complied with them, and one bidder hasn't because they've made some minor error, are you not acting in a way that is transparent and acting in a way that demonstrates equal treatment and proportionality? Are you required, in a sense, to try and make up for a bidder's inability to, say, complete a spreadsheet or complete a spreadsheet and then make some minor errors? It is quite interesting. So why is this case important? Well, it clarifies the clarification duty. Judgment provides critical guidance on when contracting authority should seek clarification rather than exclude bids. It establishes that failure to clarify minor obvious errors can render exclusion unlawful. Case underscores the need for clear drafting in ITTs. Ambiguous terms like discounted were interpreted differently by parties leading to litigation. Balancing fairness and competition. By ruling that Optima should have been awarded the contract, the court reinforced that procurement decisions must not undermine effective competition through rigid or disproportionate application of rules. Practical impact, well, it's quite obvious, really. You have to be very clear about what you require, how you require it, and if you spot any obvious errors that a bidder is making, which can be corrected, then it would suggest there's almost a duty to do so, which I think is pretty onerous, really. Now I'm going to move to this area, which is some areas of ambiguity, which I think exist under the Act, which I'll just trot through relatively quickly. Automatic suspensions is the first one. Under obviously the public contract regulations, where a supply issued proceedings, as we've discussed, you have the automatic suspension that comes into effect. And to lift the suspension, then the court applies the American cyanamide test, which, just to remind ourselves, is there a serious issue to be tried? Would damages be an adequate remedy for the claimant? Where does the balance of convenience lie? Now, this is the general civil litigation test. There's nothing special about it. It applies to all injunctions that are sought. It just so happens that it's relevant to the application of the automatic stay, because, of course, people apply to have the automatic stay removed. So that's why it's relevant in these circumstances. However, under the new Procurement Act, or the Procurement Act 2023, that introduces a new bespoke test for lifting automatic suspensions. And instead of focusing on the adequacy of damages and the balance of convenience, courts must now weigh two competing factors. And that is, one, public interest, the need for timely delivery of public services, avoiding disruption or cost, i.e., is there a public interest in allowing this contract to go ahead, notwithstanding that damages may ultimately be awarded and the party who is aggrieved gets damages? We must allow the machinery of government to move on. And also it balances that against suppliers' rights. ensuring fair treatment and effective remedies for bidders who allege breaches. So this is the other side of the coin. Is it not unfair to lift suspensions if ultimately a supplier's rights are being infringed? Because are damages genuinely a remedy that are worth having? It might prove to be the case that a supplier thinks not and then abandons the proceedings. Now, it's said that the Act deliberately moves away from the American Simon test to reflect the unique nature of procurement disputes where delays can affect critical services. I can understand that. I can understand that logic. The only difficulty, I suppose, is that the Act doesn't specify which factors should carry more weight, i.e., how are you supposed to apply the discretion? So should urgent public services need to override suppliers' rights, or should preserving competition and fairness take priority? So this lack of hierarchy between those two things creates uncertainty for contracting authorities and suppliers. And I suppose the difficulty is that, unlike the American Sanoma case, which of course has a mountain of case law to support it, this new test is a bit open-ended, meaning it's very difficult. Meaning outcomes may vary significantly depending on judicial interpretation. We simply don't know. The basic point is as to precisely how this test is to be applied, because we don't really have any case law to support it. So I suppose that's an area of significant uncertainty, and it may well be that a lot of the cases that deal with the whole kind of approach to automatic stays completely changes. We may go completely away from the American Sony case, or the courts may think, well, actually, we much preferred that approach, and we're not really very keen on adopting these revised approach, and will effectively reinvent that test for the purposes of the Procurement Act. So what are the practical implications? Well, they're always the same. I mean, the implication is the same primarily, which is you've got to have very strong evidence to demonstrate why a stay should remain in place. So from authorities' perspective, you need to show what public harm is caused if a stay remains in place, i.e., how services might be affected, what consequences will arise from it. And I suppose suppliers, again, would need to demonstrate why their rights are being undermined and their effective remedies taken away from them. So, as I say, it may well be that we end up in exactly the same place where we are now, by effectively the courts determining that these provisions are effectively American Sinomad in disguise, or it may well be that we have a totally different body of case law. Who knows? Moving on to disbursement lists and exclusion grounds. As I say, there's a new mandatory and discretionary exclusion rules are broader. Yeah. Ambiguity. How far does connected person's liability extend? What evidence suffices for exclusion? Yeah, I suppose the point I'm just making here is one of the areas which is slightly difficult to establish, it seems to me, is how far does a connected person's liability actually extend? So it strikes me that it's still not clear. Does it include parent companies, subsidiaries, directors, subcontractors, and key personnel? How much control or influence must exist for misconduct to trigger exclusions? And I suppose it just isn't very clear in the legislation now. Whether or not it'll become clearer may be the case in due course, but it's still an area of significant ambiguity. So I think that it's important that that issue is given some further thought at some stage. Standstill times and limits, 8 working days to trigger automatic suspension and 30 days for claims is quite tight. And arguably there might be some confusion that still exists around when the clock starts, especially for dynamic market and framework call-offs. The standstill and time limits issue under the Procurement Act is quite a critical challenge for both suppliers and contracting authorities. The Act retains 2 key timeframes: 8 working days for suppliers to issue proceedings to trigger automatic suspensions, 30 days to bring a claim for breach of procurement rules. Not dissimilar to the old standstill period, although I suppose the same principle applies. These are relatively short periods, but But I think that that's not really the problem. I would suggest that the real problem is it's not 100% clear, it seems to me, that when the event triggers, what event triggers these deadlines? Is it when the standstill notice is sent? The date the supplier receives the notice? It is a little bit confusing, it seems to me still, and not entirely clear. So that's an area that probably needs a bit of further clarification. And also, of course, I suppose even under the existing, I mean, it's a pretty obvious point to make, but it's still not, obviously, we have this new competitive flexible procedure, which is very broad. And I can understand why it was drafted that way, because it gives the ultimate flexibility as to the nature of the process that a contracting authority adopts. But we're still not really 100% sure, or I'm not entirely sure, how that should be applied in specific circumstances. And in many respects, it's just a matter of sitting out and waiting and to see, what the outcome is of any cases which look to interpret how a council or public body approaches, or contracting authority rather, approaches the exercise to determine, what approach is taken. Sorry, I've gone too far there. And then again, transparency in publication dates, mandatory notices, etc. For KPIs, contract changes and performance royalty increases compliance burden. Well, yeah, that's fair enough. But a grey area, I suppose, is what constitutes a substantial modification that requires a notice. Again, it's not massively clear, and something that might be worth considering. But they're just points really that are worth taking into account. They're just some areas I've picked on, which I still think aren't necessarily as clear as they might be. But over time, no doubt, as we have more cases, which I was hoping we might have by now, we'll be a lot clearer on where things stand. The last thing I wanted to talk about very briefly is this Thomas et al. And Durham County Council case, which I only became aware of in the last week or so, which I think is really quite interesting. It's interesting because it's unusual and quite strange. And also it's interesting because it brings together two entirely separate branches of law. And even the way in which the claim is brought is slightly odd. And in this case, the claimant is a guy called Mr. Graham Thomas, who I think is associated with a number of companies. And the defendant is Durham County Council. Now, the claim was issued on the 19th of September, 2025. Sorry, it was filed on the 19th of September. It was published on the 21st of October, 2025. And what the claim alleges is that a number of grants were awarded by Durham County Council in breach of a variety of different legal principles. So it challenges the lawfulness of these grants, the transparency and proportionality, regeneration funding, decisions made by Durham County Council in Bishop Auckland. And I've listed the particular claims, the particular grants are in dispute. Now, the allegation is that there was a lack of competitive tendering for the STAC grant, i.e. that there was an extent to which grants were effectively just given out to particular bodies without some kind of competitive process. Well, you might argue, why do you need a competitive process to grant? But anyway, delayed public disclosure of the marketplace grant, incomplete delivery of the Artist Hub project despite funding. There's also this argument about conflict of interests, disproportionate influence of Auckland project within the Stronger Towns bid. So the basic, and then there's also an allegation of unfair treatment of Mr. Thomas and his companies, who were initially awarded £315,000 for a generation project, but later denied further funding despite assurances. So effectively, Mr. Thomas was upset about the fact that he'd received some funding but didn't receive much more, that he felt that the way in which the grants were being awarded didn't comply correctly with a number of different principles, whether it's public law principles, procurement, subsidy control, a whole range of things. And what's interesting about the case, though, is that it wasn't actually brought in the traditional High Court, it was brought in the Competition and Appeals Tribunal. And so it's predominantly focused around subsidy control. Now, of course, subsidy control is relevant in the context of awarding grants, because clearly if you give a grant to an enterprise and you economically advantage that enterprise, by virtue of that grant, then potentially you're providing them with an unlawful subsidy because you may interfere with the normal operation of the market by effectively favouring or giving a financial advantage to one of its operators. So that's the basis on which this is brought. But what I think is quite interesting about the case is that it seems to me that in the context of subsidy control, what you are beginning to get is this kind of feed through or feedback loop into procurement, because of course there is then an argument for suggesting that if you had some kind of competitive process and therefore there was a level playing field in terms of who was to receive grants, then arguably you address the subsidy control problem because it's effectively a fair competition. It's a grant competition in effect rather than a procurement. And one of the great advantages of having some kind of procurement process is that, of course, if it's open and available to the market at large, then you can demonstrate that everyone had a fair shout, and therefore no one who then the winning bidder who's successful wasn't more financially advantaged than any others in being awarded that contract because it was a fair competition. So what you seem to be getting through some of these cases is an analysis of whether or not, in the context of the awarding of grants, whether or not they constitute some kind of quasi procurement type arrangement, or do they instead simply need to comply with normal public law principles, or are they indeed some kind of subsidy control issue? So I find the case interesting for those reasons. As I say in this slide, its case is odd because it was brought in the Competitions and Appeals Tribunal under Section 47 of the Competition Act. Not the Subsidy Control Act, although that's what the Competition Appeals Tribunal normally deals with. The other parts of this is quite interesting is it potentially opens up that whole can of worms around whether or not a grant is a procurement. Now, conventionally, it's not because the services are not being delivered to the authority. They're being delivered, the authority is providing finance so that third party receives the benefit of those services. And that's always been the conventional approach. People always said grants are not procurements because of that reason. I'm just wondering whether or not you may end up in the future finding yourself in a situation where the courts begin to start to look at some of grant agreements and say, well, really, is it genuinely not a public works, sorry, a public contract? Primarily because if it delivers certain outputs which are regulated, then why shouldn't that be subject to some kind of procurement process? Why should it be the case that in the context of a grant that you can argue that it falls outside of the procurement rules if ultimately using public funding to deliver something just because it's being delivered to a third party doesn't necessarily mean that it should be exempt from those rules. And also, it would appear that we're starting to get into the whole grants world, this idea of application of Regulation 18 type principles, of fairness, transparency, non-discrimination, which is interesting. So I say it's all very speculative at this stage. It's very difficult to draw any conclusions purely from the basis of the claim. I know that there was an article published yesterday by leading barrister who advises on subsidy control was saying that the case was the people who were bringing the case were poorly advised, and that fundamentally there isn't any possible real basis for any kind of subsidy control angle because none of the recipients are potentially were enterprises and therefore they wouldn't be caught. But as I say, it's just interesting, it seems, from my perspective, how subsidy control, which is really all about ensuring fair competition, is sort of actually beginning to influence potentially procurement type scenarios because it's dealing and grappling with procurement type issues. And I can see how potentially some of these things which traditionally weren't caught by the procurement rules or the Procurement Act potentially could be. But as I say, it's early days. The claim was brought in a very strange venue, Competitions Appeal Tribunal. So I don't think we necessarily need to read too much into this stage. It could be that the case is dismissed quite early on and we never hear about it ever again. But it's always been of interest to me personally, this idea of what's a grant and what's a procurement for a service and or the delivery of some kind of works or supply. So I think that's where it's interesting. So that brings me to the end. Oh, it's 1 o'clock already. So let's just see, have we got any questions? Any points anyone would like to raise? Any questions for anyone? Can't see anything. So I'm looking in the wrong place.
Hi Nathan, there's a chat,
Hi.
one in the chat and one in the
Oh,
queue.
is there?
Oh, there's two in the
Okay.
Q&A now. Thank you.
Sorry. Yeah, in the Q&A. Hang on a minute. Let's see if I can find that. Where's it gone? Oh yeah, sorry, it was hidden. Yes. Yeah, one of the questions is I'd always understood that there's still a relevant PCR regulations in relation to call-off contracts entered into. Yeah. Yes, that's true. They're still relevant in relation to Regulation 72. I didn't mean to mislead on that basis. Yeah, I think what you're effectively saying is that the same rules apply and continue to apply, including variation of contracts. Um, yes. So yeah, wouldn't suggest that. I think that the rules as they apply currently would continue to apply all the way through to the end of the contract, including variations. Yeah, I know. I agree with that point about. So somebody said, I'm aware of many GFAs that have direct benefit to councils. I believe this topic needs to be addressed as the majority of LA lawyers use GFAs to bypass procurements without realizing it. I think that's probably true, that there is a very fine line between grant funding agreements and procurements and whether the benefit is actually for or not for the authority. Uh, got another question here, which I think I'll have to take away. And could you briefly explain the... I have to come back on that one as well, I think. So yes, fine. Sorry, yes, there are a couple of questions I'll come back on, but I'll publish them, and Julie can. Once I've had a look at them, I'll give answers to all of them, and Julie can recirculate them with the slides. But it's going to take a little thought on some of them to come back on those. So I think that's those ones. Are there any others? Let's have a look. Look in the chat. Oop. Yeah, I think I've looked at all the Q&A ones. Yeah, I've done all the Q&A ones. Okay, so I'll say I'll come back on those questions. I've only cited a couple of them, so I can answer those now, but I'll come back on the other two in due course. Oh, there's another one. Yeah, I'll come back to you, Senol, Mustafa Senol. Yeah, that'd be great. And that's it, I think, unless anyone wants anything else to raise. Julie, I think you can.
I think that's everything,
Yeah,
Nathan.
okay. Thank you very much. Thanks for coming. I'll fill in the feedback forms.